Imagine the scenario. A family already dealing with just unimaginable medical crisis. Then on top of that grief, they face this really perplexing legal interpretation, one that seems to just deny their basic right to make end-of-life decisions for their loved one. This is exactly what happened in the really resonant case of Adriana Smith. So for this deep dive, we're going to unpack the sources surrounding this incredibly complex situation. You've got medical ethics, patient autonomy, restrictive laws, all tragically colliding. We'll explore how this one woman's story really sparked a nationwide debate. It's forcing us all to look at the unforeseen impacts laws can have on these deeply personal medical choices.
Yeah, and what's fascinating looking at the sources here is how they reveal this profound tension. It's not just about the specific facts of this case, but, the wider implications when there's ambiguity in the law itself.
Yeah.
It really makes you ask, how do our systems actually respond when these legal texts meet real individual lives head on?
Okay. Let's dig into this tragic situation. Let's focus first on Adriana Smith herself. The sources tell us she was 31 years old, a nurse, and she was about 8 weeks pregnant when she was declared brain dead back in February. This followed a sudden health emergency involving blood clots.
Right, devastating situation already.
Exactly. And this is where it gets really complicated and just profoundly heartbreaking for the family. According to her mother, April Newkirk, officials at Emory University Hospital, the Midtown location in Atlanta, they told the family something quite specific. They said they, quote, could not remove Smith from her life support due to state law that bans most abortions after 6 weeks.
Mm-hmm. And the sources really bring home the emotional burden that put on the family. April Newkirk described it. She called this protracted situation torture, just sheer torture. She talked about the pain, saying, I come here and I see my daughter breathing, but she's not there. And she added, it should have been left up to the family. That feeling of powerlessness comes through so strongly.
It really does. And the sources quote her again, capturing that depth of anguish. It's hard to process. She says, I shouldn't be burying my daughter should be burying me. I mean, that just encapsulates the immense emotion, the psychological distress when these end-of-life decisions get tangled up or even overridden by these legal interpretations.
Absolutely.
So let's turn to the law itself. What exactly is this Georgia law that was cited? What are the key parts that might have led to this?
Okay, so the law in question, it's officially the Living Infants Fairness and Equality Act, the Life Act, but it's widely known as the Heartbeat Law.
Mm-hmm.
And the sources outline its core function. It bans most abortions after roughly 6 weeks of pregnancy.
Okay, 6 weeks. Are there exceptions?
Yes, there are limited exceptions. The sources mention medical emergencies, pregnancies deemed medically futile, or cases of rape or incest, but there's a condition there. A police report has to have been filed, and the fetus must be less than 20 weeks.
Right, so the real flashpoint here seems to be how that law was actually applied by the hospital, or maybe, misapplied. The sources point to a really stark disagreement on that, don't they?
They absolutely do. It's central to the whole controversy.
Mm-hmm.
So while the hospital reportedly pointed to the Life Act to justify keeping Adriana on life support, Georgia's Attorney General, Chris Carr, he explicitly pushed back on that interpretation. Hard.
Okay, what did he say specifically?
He stated, quite clearly according to the sources, there is nothing in the Life Act that requires medical professionals to keep a woman on life support after bone death. And he added, crucially, removing life support is not an action with the purpose to terminate a pregnancy.
Wow. That's a fundamentally different reading of the law's intent and scope.
Exactly.
And Georgia Senator Nabila Islam Parks, she echoed that concern too, right? She called the hospital's reported decision an unusual and deeply troubling interpretation of the law. So this scenario perfectly illustrates how, ambiguity or maybe even just fear of legal repercussions, how that can lead medical professionals or maybe hospital administrators to make decisions based on these cautious, potentially overly restrictive interpretations, even when the state's own top lawyer is saying, no, that's not what the law requires.
Precisely. And that raises the question, what are the broader implications here? Beyond this one tragic case, what does this mean for medical practice, for patient rights, maybe even across the country?
Well, the sources definitely pick up on that. They say Adriana Smith's case, quote, kicked off a nationwide debate, a debate specifically over how restrictive abortion laws can cause confusion for medical professionals who are trying to, care for their patients' health while also towing the line of the legislation. So it highlights this systemic challenge. It suggests it's not just an isolated incident or misunderstanding.
And it circles back to that fundamental issue of informed medical consent, especially, as you mentioned, when a patient is incapacitated. Senator Parks really hammered this point home. She said, "Women deserve the ability to give informed medical consent. And when they cannot, their families must be empowered to make decisions with full information and without fear."
That without fear part seems key, given the context.
Absolutely. And the sources suggest this might not be an isolated issue even within that same hospital system. They mentioned another patient at Emory Midtown, Avery Davis Bell. Her necessary life-saving care during miscarriage was reportedly delayed. Why? Because doctors were concerned about the 6-week abortion ban.
So that does suggest a potential pattern, or at least a recurring chilling effect from the law.
It certainly underscores the systemic challenges that healthcare providers are facing when they're trying to navigate these really complex, sometimes confusing legal landscapes.
Okay, so let's bring everyone up to speed on the immediate outcome in Adriana Smith's case. What happened next? Her baby, a boy named Chance, was delivered prematurely. It was via C-section on June 13th. He weighed just 1 pound, 13 ounces.
Very small.
Very small. According to April Newkirk, his grandmother, Chance is in the neonatal intensive care unit, the NICU. But she said he's, quote, expected to be okay and is just fighting. He's Adriana's second son.
A small bit of hope in a terrible situation.
Indeed. And Adriana Smith herself, she was expected to be removed from life support just a few days later on June 17th following Chance's birth. But it's really important to stress the family's consistent position throughout this ordeal. As April Newkirk stated, it wasn't necessarily that they would have chosen to terminate the pregnancy. Their fundamental point, their fight, was about the right for them, the family, to make that decision. Not the hospital, not the state, based on this interpretation of the law.
Right. And that's a crucial distinction. So while the baby's birth provides the specific outcome to this particular chapter, it doesn't really resolve that underlying tension, does it? The tension between family autonomy, medical ethics, and how these laws are interpreted and applied in real-time, high-stakes situations. This case really serves as such a powerful, poignant reminder of how these profound personal tragedies can suddenly become central to these critical, often contentious public debates.
Absolutely. This deep dive, I think, really underscores that crucial tension you mentioned. You have the profound grief of a family. They're caught between the hospital's interpretation of a state law and the state's own attorney general explicitly saying, no, that interpretation was incorrect. It's a heartbreaking conflict.
Yeah. And this really prompts an important consideration for you listening to this. In this increasingly complex legal landscape and medical landscape too, how do we make sure? How do we ensure that individual autonomy, that family rights, remain truly at the forefront of these deeply personal medical decisions, especially in difficult end-of-life care situations?
It's a tough question. And this story, Adriana Smith's story, it serves as such a poignant reminder. It shows that even laws that might seem clear on paper can create these unforeseen ripples, ripples that leave families and medical professionals too trying to navigate some very murky, very difficult waters. It's definitely a powerful thought to mull over and something to keep in mind as these kinds of conversations inevitably continue to unfold across the country.